Good afternoon, everybody, and thank you for joining us today. I'm Vidisha Prithviraj. I am the CEO of LexisNexis South Africa and chairperson of the board. And I think in this capacity, I can definitely really relate to the business and financial challenges that us as key business decision makers have to grapple with currently. And so I think this is a very topical webinar for us to have at this time. And so for today, I will be your facilitator for the session, and just some ground rules before we get started. So everybody will be on mute for the duration of the session, except for the speakers, which is Eric and myself for now. Eric will take us through his discussion on business rescue in the time of COVID-19 for around 20 to 25 minutes. And thereafter, we will have a Q&A session with all the participants. For those of you that have been very proactive and have sent us questions already, we thank you, and we will be going through those as well. But for those of you that have additional questions, please feel free to use the Q&A box at the end of the presentation to send us your questions, and we will try to get through all of them in the allocated time. So for me, the honor of having to introduce Dr. Eric Levenstein is quite amazing. I think Eric, in many spheres, especially in the legal industry and even in the corporate industry, does not need much introduction. But I want to do him proud, so I want to just give you a few facts around his career to date. So Dr. Eric Levenstein has been a director at Worksmans since 1993. He is the head of the firm's insolvency, restructuring, and business rescue practice. He is also the chairperson of the South African Restructuring and Insolvency Practice Association. Eric sits on the board of Insol International, which is a worldwide group of insolvency practitioners. And from a LexisNexis perspective, we have been very honored to have enjoyed a mutually beneficial partnership with Eric over many, many years, as he has authored the South African Business Rescue Procedure, which explains basically the law applicable to businesses around rescue procedure and examines some of the practical challenges we all face in the implementation of these procedures. Eric's expertise also extends to director liability, and I see we've had some questions on those already, which we will cover later on. And he regularly delivers seminars and webinars, and also writes for various publications on these topics, amongst many others that he is also an expert in. So Eric, I hope I've done you proud in terms of doing a little bit of an introduction in terms of the amazing work and in terms of also the kinds of contributions that you've made to the legal profession and the assistance you've provided to many corporates during your short career thus far. So let me hand it over to you. Eric will be speaking to us, obviously, as I said, on the business and financial impacts of COVID-19. And, there are a plethora of benefits that we see that can be derived from considering business rescue as an alternate avenue to some of the other decisions that businesses might make. So I think many of the key business decision makers that are on here today, Eric, are looking to you to help them get an arsenal of tools to understand what are some of those alternatives, but also why is business rescue one of the things that all business decision makers should be looking for, and maybe also helping us a little bit in terms of business rescue always sort of sends up a bit of a red flag for directors and employees alike, but also to help us maybe understand why business rescue is a very viable alternative to some of the other avenues. So let me hand over to Eric to take us through the next 20 to 25 minutes.
Thanks, Vidisha, for that introduction. I appreciate those words, and also to LexisNexis for hosting myself and Worksmans today on this topics, and particularly in relation to what I think is a very timely webinar when looking out at the economy, looking out at the level of financial distress that we're seeing on a daily basis. So I'm really looking forward to the session, and in particular to the questions and debate that I think we will have later on in the afternoon. So I hope everyone's keeping warm and that you're all safe and healthy and are coping with the continued fallout from COVID-19. I'm going to share with you this afternoon, in the first part of the webinar, some of my insights, work studies and case studies that I've been working on probably since March of this year, when COVID-19 became a reality in South Africa. And it really has left restructuring lawyers like myself, restructuring experts, turnaround specialists and insolvency practitioners extremely busy in this area of practice. And it is all about the restructuring and rescue of financially distressed companies and businesses. Now, what is interesting, as we've seen since around about February, March, is the fallout and the financial distress levels is completely industry agnostic. It touches every form of industry, every form of business, and cuts across what we would experience in the country, whether it's in the hospitality industry, the airline industry, etc. And I'll deal with some of those examples later on. So just wanted to just share with you some of my thoughts on challenging trading conditions. What we saw early on in the year was the downgrade by Moody's of the South African sovereign credit rating to sub-investment grade. And this came almost to the day, or very, very close to the day, that our president announced the national state of disaster and the lockdown that we experienced on Sunday, the 15th of March, 2020. It seems a long time ago, but it certainly was something that rocked industry and the economy. So not unexpectedly, we had this downgrade, junk rating status from all three major credit rating agencies. And as a result, South African bonds, government bonds, were excluded from the FTSE World Government Bond Index. And for South African corporates, it became an issue because it became more expensive to borrow money. And I think the International Monetary Fund, the IMF, immediately gave a growth forecast for South Africa for 2020, reduced it to 0.8%, and for 2021 to 1%. So there's no doubt that that ratings position early on in the year affected the South African economy, and certainly provided extremely challenging trade conditions in South Africa. And then came along our COVID-19 lockdown. On the 25th of March, lockdown regulations were imposed. We've seen them come and go, mostly downgraded now to level 3. But unfortunately, we've seen continued infection rates which remain on the incline. And recently, even though we've seen a further pushback on alcohol sales and on further effects of the lockdown like curfews, it remains very difficult in South Africa and worldwide to continue to do business, and which obviously has a knock-on effect on what we term financial distress. So currently, government regulations provide harsh trading conditions for all South Africans and really prejudice the ability for companies to continue to trade successfully. I think that what I'd like to share with you now is something called the Recession Pain Index, which was pushed out by the IMF early in this year, around about April, which provided a very interesting statistic on which countries are going to feel the recession in the early term as a result of COVID. And we see from this graph that the United States was at #1 as the country to be most affected by the recession caused by the pandemic. And then it goes on to rank South Africa at #2, followed by Italy, France, the UK, and Turkey. So the IMF certainly looked at South Africa, and it does not look pretty. The projections again for the second half of 2020 from economic growth was set by the IMF at a -3% and a downgrade of 6.3% from January this year. And what the IMF had to say, which is very interesting, is that the great lockdown, is what we're living through at the moment, has really contributed to the worst recession since the Great Depression in 1929, and far worse than the global financial crisis in 2009. So what does this mean for South African businesses? So in my practice and in what we do at my firm is we engage with directors of financial distress companies, with management, with financial institutions and banks that might have customers going through this turmoil, and we try and obviously assist by using what is available to us, mostly focused in terms of the Companies Act 2008. And we've seen fallout. We've seen clients come to us across the board, hardships in sit-down restaurants, hotels, hospitality, conference centers, entertainment venues, sports centers, and sport event companies, and in particular the transport sector. As we've seen, the airline industry, together with retail and construction, have become severely constrained. And the most interesting one that I think everyone's kept their eye on is South African Airways. And obviously, we've had some breaking news today that, in fact, the government and the Minister of DPE and the Minister of Finance have, in fact, provided late last night, Wednesday evening, with a letter of support for the business rescue practitioners, indicating that there will be finance provided to the business rescue process at SAA. What is interesting is with SAA is that its business rescue plan was in fact voted in on Tuesday this week at 86% of all creditors voting in favor of that business rescue plan. Now, when you go back and read the press and look at the media over the last couple of months, it is quite a startling outcome, particularly with the level of hard negotiation with trade unions, employees, the South African Airways Pilots Association, etc. Government has committed to an additional 16.3 billion rand of funding. And as I've just said, the letter of commitment has been made available. And we are hoping that that funding does become part of this rescue, particularly because of the potential saving of jobs within the airline industry and particularly within the SAA framework. We've also seen Comair go into business rescue, and that is something I'll touch on in a minute. And also Edcon filed for business rescue in terms of the Chapter 6 provisions in the Companies Act. So there certainly has been an uptick in the number of case studies and examples of rescue. We've certainly seen, as I said, Edgar's, and in fact, we've also seen in the horse racing industry, Phumelela go into business rescue, and in fact, we've recently seen the prospect of funding coming into the company, Phumelela, with hopefully some prospects of a new owner taking over that particular entity. So there's no doubt that the prospect of companies and businesses not being able to hold out within this economic environment has become a very stark and very concerning reality for all of us. At the same time, and looking at these three examples, I think we are seeing a significant number of asset sales and transactions. For example, SA Express, also in the airline industry, went into business rescue and then into liquidation. But even in provisional liquidation, SA Express are looking to sell off aspects and parts of their business. So there are transactions that are happening within the business rescue context. And I think those companies with strong balance sheets and with cash available can look from an upside perspective and look to see whether they can get to a transaction which allows them to buy assets out of business rescue, provided obviously they've got cash available to do so. So business rescue is fast becoming a new playground for what we call M&A, merger and acquisition activity. Now, that's just a picture of the South African Airways aircraft. The plan was just being approved. There's going to obviously be a lot of hard work to do going forward, both for our various ministers and of course for the business rescue practitioners. So looking at South Africa and the continued stress, the knock-on effect of the actual lockdown has been quite interesting to see, and obviously very, very depressing at the same time. Some companies have reopened in level 3, for example, but it's significantly reduced capacity. Not being able to have generated revenue for 2 to 3 months has had a knock-on effect where they are unable to pay revenue or not be able to generate revenue to pay expenses like the lease obligations, their suppliers, their employees, and other contracting parties within the framework of their business. So a lot of these companies have in fact been placed into what we term financial distress. We have not got statistics from the Companies Office, from SIPSI, which provide us with exact detail of how many companies have gone into business rescue, but we have seen definitely, in my experience, and I'm sure a lot of my colleagues will agree, an increase and an uptick in both liquidations and business rescue. I think really for distressed companies, they can't just kick the can down the road. There must come a point where hard decisions need to be made, and to look at things like potentially the intervention of a business rescue practitioner, or maybe even an informal restructuring expert to assist them. So let's just look at some of the concepts that we have to grapple with. The first is financial distress and reckless trading. So in the Companies Act, the test for financial distress is quite clear. If a company cannot pay its debts in the next 6-month period, or it's going to be insolvent in the next 6-month period, then there has to be an intervention on the part of the directors. If not, directors could be held personally liable for reckless trading, for trading a company in insolvent circumstances. So a lot of the clients that come to see us are looking for that kind of advice. Is the company financially distressed, and is there a need and a requirement to in fact file for a formal business rescue process? The second is, over the last few months, we've seen this, what we call a quasi-moratorium on debt. So a lot of the companies that are distressed, can't generate revenue, have gone to their counterparties, their landlords, their bankers, and asked for debt holidays, payment holidays, and really asked for a moratorium on payments to their counterparties in business. Now, some have been successful, and others, unfortunately, have resulted in these companies, in fact, having no alternative but to either file for business rescue or alternatively liquidation. So this whole quasi-moratorium can be quite dangerous, because if you're asking for some kind of moratorium from your creditors, those creditors could in fact apply to court to apply for your liquidation. The problem, of course, is that in this scenario, there's no moratorium on companies applying to court, execution against company assets, etc. So the quasi-moratorium informal restructuring space is a very dangerous place to be. And a lot of people have criticized some of these companies. In other words, they've used the current economic situation, let's say from an abuse perspective, and using harsh trading conditions to buy time, when in fact their businesses are not viable and are not sustainable. So there has been some criticism for those companies that are probably candidates for liquidation as opposed to business rescue. And then lastly, the danger of liquidation. One must never forget that aggressive creditors have the option to apply to court to place companies into liquidation when they are not being paid. And all of this ability and kind of approach to talking to your creditors to ask for payment holidays and moratorium on payments can backfire in a very harsh way, where in fact the companies can end up in liquidation. So what are the opportunities? What have we seen in practice in relation to what's going on with the knock-on effects of COVID? And one that I've come across is the opportunity, in fact, from a positive perspective, to allow companies to reset their businesses, either through an informal restructuring process or through the business rescue proposition. Now, as I said earlier, informal restructuring is really where you'd go out and get an industry expert, an informal restructuring expert or a turnaround expert to come along and try and assist you when, in fact, you are running out of cash, you can't pay your debts, and you don't necessarily think business rescue is there yet. The problem, again, with informal restructuring is that there's no moratorium. Again, talking to even a small number of creditors can backfire, which could relate or translate rather into an application for the company's liquidation. So I think informal restructuring is certainly an option, but when companies are faced with threats from aggressive creditors, then I'm afraid the only alternative is a possible business rescue filing, or at worst, placing the company into liquidation. There is talk about a CRO, a Chief Restructuring Officer, being appointed in an informal restructuring space. We haven't seen a lot of those in South Africa. There was at a time a CRO at SAA, and we have seen CROs appointed from time to time. But it's not something that's taken off like we've seen in the United States, for example. And then business rescue, what is it all about? It's when you're financially distressed, as I've said, you appoint an independent supervisor to come along, sit together with the board, and try and restructure the company to come out with two objectives. One is to either allow the company to trade out on a solvent basis so that the company can continue to trade, or alternatively, if that's not possible, to deliver a better dividend than you would get in a liquidation to creditors. And that's a very difficult balancing act between the two objectives. It's not necessarily one or the other. Sometimes we've seen a hybrid of both of those objectives landing in a business rescue. What are the advantages of a business rescue? The practitioner would take control, which alleviates the pressure that is being brought to bear on the board of directors. The objective, of course, is the publication of a business rescue plan that must be approved by creditors. And really the effect of the plan is the restructuring and rescue of the business. Our plans are really a contract between the business rescue practitioner, the company, and its stakeholders, and in the main creditors. So creditors need to be engaged, they need to be brought on board early in the process in order to ensure that, in fact, when it comes to the voting on the plan, they support the business rescue plan. As I've said, it does impose a statutory moratorium on claims, a stay on claims, which is an international piece of restructuring, which we see in Chapter 11 in the United States, particularly in other jurisdictions as well. And then post-commencement finance or funding must be obtained. Now, what is post-commencement finance? Once a company goes into rescue, it must be able to be propped up in the sense that it's got to be sustained as a viable entity. So you need post-commencement funding or finance. Now, where does that come from? Generally from the existing banks and financial institutions that the company has already been engaging with, or from third parties, distressed funds that might put up this finance, or potentially from an offeror who's coming along to buy the company. They themselves might put up some funding to make sure that there is some value in the company when they ultimately do a transaction, an acquisition in the business rescue itself. So post-commencement financing is the lifeblood of any finance, of any restructuring process, particularly business rescue. It enables the company to make what we term a fresh start. And of course, the main part of business rescue is leaving behind burdensome debt. And really what the plan would offer is a compromise of that debt, where creditors have to accept that they're not going to get 100 cents in the rand, something a lot less, but of course better than what they would get in liquidation. Practitioners are also allowed to suspend and cancel contracts, particularly prejudicial contracts that are dragging the company down and which prejudices the ability of the practitioner to, in fact, rescue the company. Once you're in rescue, directors can, to a large degree, breathe a sigh of relief because the opportunity for reckless trading has now gone. You've now handed over the company to the practitioners, and the reckless trading issue is no longer relevant. And lastly, it allows for the mothballing of the business. So the company can, particularly in this COVID-19 scenario, can be mothballed. So for example, take Comair. Comair is being mothballed at the moment. Their planes are in hangars and are not flying at the moment because of the restructuring through the business rescue process. And the practitioners have advised everybody that they will probably not start flying until 1 November, maybe slightly earlier. But really what they're doing is they are ring-fencing costs, ring-fencing very burdensome debt to give the company a chance for a fresh start and hopefully post 1 November of this year. Now, directors find themselves in a very difficult situation. Even once they hand over the business to the business rescue practitioner, there's still the possibility of them saying to themselves, why do they need to stick around? Shouldn't they just exit from this process? What do they need business rescue in their lives at all? And it's a very delicate balancing act. And we've seen business rescue practitioners obviously consult directors. Remember, practitioners come into this scenario in a very cold and not much information available. So they rely on directors, particularly the financial director and other members of staff, to provide them with proper financial information, which will enable them in time to draft a plan and get to a position where they can, in fact, get a plan voted in and, in fact, approved. So directors face a very difficult task. Of course, what we've seen from certain directors is some of them start the process far too late when there's not much left to rescue. But when properly advised, rather, directors should take legal advice, and particularly if they want to protect themselves from trading a company recklessly and not handing over the company to a business rescue practitioner at an early enough stage. So the dangers of reckless trading are there, but the intervention of directors making hard decisions, and where leaders really have to step up to that role in making the harsh decisions when actually admitting that the company cannot continue to trade in its current context and that there needs to be some form of intervention. Is there a silver lining in all of this? I think probably there is, and I think it's all about companies being given an opportunity for a reset, for a restructure, particularly where the company itself is probably, even before COVID, was teetering on the edge of financial distress, maybe potential insolvency. So a lot of what we are seeing is, in fact, companies that were probably going to end up on the scrap heap, at least looking at business rescue and using the Chapter 6 legislation to its advantage in fact, bringing independent professionals on board to try and assist them in a restructuring. Of course, what we don't want to see is companies fail, because if companies fail, they go into liquidation, jobs go out the window, the company's life comes to an end, suppliers no longer have the opportunity to engage with that particular company and earn revenue. So there's a very bad knock-on effect when companies go into liquidation. Some suppliers or contracting parties themselves might find that they have to file for either rescue or liquidation because their very reliant counterparty has gone into a formal process. So I think there is some silver lining. I think there are also potential let's say, opportunities to acquire companies. Even though they might be financially distressed, run out of cash, there might certainly be an opportunity to acquire those companies, bring them into the fold, into your organization, where 1 + 1 might in fact equal 6, and there's some significant upside. So Vanessa, just to end off, I'm going to just leave our participants this afternoon with some thoughts, and they really are: think about restructuring. Don't leave it too late. What's very important is to involve your turnaround specialist, your attorneys who are skilled in restructuring at an early stage to get proper advice. Because if you leave it too late, as I've already said, there's just not much left to rescue, and the value goes out the window. Always consider the informal restructuring process. It is an option, but as I've said, there's no moratorium or stay on claims, and it can become a very, very dangerous place to play when there is no moratorium. And if appropriate, don't be scared to file for business rescue. Of course, the legislation has only been with us since 2011. Prior to that, all we could actually do is put companies into liquidation, which is a very negative outcome for the company and for the South African economy. So I think everyone needs to think out of the box. We need to be proactive, we need to be diligent, and we need to, most importantly, be aware of available options, like obviously attending hopefully a webinar like this afternoon, and to gain some knowledge of what the options are, and what is this thing called business rescue, what is an informal restructuring, and how does liquidation ultimately work. So Vidisha, that's it for me. I was very strict with the time. It's at 2:30. So I'm going to hand back to you.
Thank you, Eric. That was my technology is misbehaving. Thank you, Eric. That was very informative. I've definitely learned a thing or 5 there. So thank you for sharing with us. So, I think in summary, you're right. I think for many of us, from a business perspective, the world has been turned upside down. There is no business as usual. If anything, it's business as unusual. It's become more a game of survival. And I think you've given us some really good points to consider before, as you said, traditionally, there weren't many alternatives. It was liquidation, that people kind of, tended towards. So it's really nice to know that there are other steps that businesses can look at. And I think the other interesting factor, as you said, is no one's really safe from this. This is company agnostic, size agnostic, industry agnostic. So, I can tell you, aside from some of the examples that you've given, I've been surprised at some of the mammoth and massive companies that have really been affected from a business and financial point of view, the likes of Edcon, and you obviously gave us some of the other examples as well. So yeah, I think that's an interesting thing, because it's no longer a factor of if you're big enough, you're going to weather the storm. This is affecting all of us. So thank you for the very interesting discussion. And I think if you had to sum up for us, what are the 3 most important factors that you would say we have to consider when it comes to running a successful business rescue process? So what are those top 3 that you think we have to keep in mind?
Vidisha, I think the most important is the appointment of the right business rescue practitioner. Now, who are these business rescue practitioners? We've seen accountants, turnaround specialists, attorneys playing in the space. And it is a very, very different skill set, for example, to a liquidator. A liquidator goes into a company, realizes assets at best, probably at fire sale values, but ends up in really winding down the company. That's why it's called a winding up. But when you look at business rescue, it is a very, very, the bar is set very high. And the skill set of these business rescue practitioners is something I've experienced now for some years. And some are obviously better than others. Some are more senior than others. We actually have senior, experienced, and junior practitioners categorized depending on which company they take an appointment in. And I think the ability to deal with people on the part of the practitioner is incredibly important. I've seen practitioners stand up in a room filled with employees, trade union representatives, creditors that are extremely upset, a volatile environment. People are facing massive compromise on their claims. But these practitioners somehow turn it around and in fact get the stakeholders to support the plan, because they realize if they don't support the plan, the company is going to end up in liquidation. And I can tell you, in liquidation, most unsecured creditors get a very negligible dividend, if not zero. Most of the upside in a liquidation goes to secured creditors. So that would be my first point, I think most important for me in a business rescue. And then the second, as I mentioned earlier on, is the availability of post-commencement finance. If you can't pay your overheads and you can't pay your business rescue practitioner or your legal advisors or your employees or your senior management, well, then you're wasting your time. If you're that far gone, then you're a candidate for liquidation. You're not a candidate for business rescue. So the post-commencement funding is vitally important. And I say that if business rescue practitioners take on an appointment without establishing whether or not there is post-commencement finance available, it's reckless. You shouldn't be taking on that appointment. You should, in fact, say to the board, you know what, this company's too far gone, rather place it into liquidation. And then the third point, Vidisha, is educating the public and stakeholders. Until South African Airways went into rescue in December last year, most people kind of thought about what business rescue was about, but they never really understood it. And I think SAA, good, bad, or indifferent, and there's been a lot of emotion, a lot of political positioning and whatever, but at the end of the day, for me, SAA has in fact put business rescue for South Africans on the map, which is a good thing because people need to understand what these opportunities are all about. So, it's about buying into compromise, understanding that you're not going to walk away with 100 cents in the rand. You're going to have to take a debt haircut, etc. And also taking the pain. I always say business rescue, and I'm a big rugby fan, is like a rugby scrum. If everyone's pushing in the right direction, everyone's going to take pain. But as long as you're all moving forward, you'll get there, and hopefully the company will be rescued.
Okay. I see we have tons of questions, but before I get to them, I think that timing is very important, Eric, is that what is that tipping point that people need to be aware of before, we're finding a lot of companies are trying to do like an informal, internal sort of analysis and, something informal versus going into proper business rescue. So is there timing or are there specific factors that people need to look for to understand we're in this stage. Okay, we've passed that. We now need to go to business rescue. And, business rescue is the option before liquidation. So what is that timing that people need to be aware of?
It's a very important question, Videsha, and it's one which unfortunately directors don't really understand. I said earlier that the test for financial distress is a 6-month window. And the reason why the legislator put in a 6-month window is get in early. Look ahead. Do you think you're going to be able to pay your debts in the next 6 months, or will you become insolvent where your liabilities exceed your assets in the next 6-month period? So it's about filing for rescue at a time when there's value still in the company, where it's not too far gone that you're looking at, as I said, a liquidation. Now, the tipping point is for me, very, very critical. And it really comes down to this. When directors are being told by management that they cannot pay their debts, creditors are knocking on their door, maybe kicking on the door, becoming extremely aggressive, they are threatening the winding up of the company, they are filing what we call these 3, 4, 5 letters of demand, which once served, there's an assumption the company is insolvent. That's when you have to consult your attorney or your restructuring expert to say, you know what, if I don't file for rescue now, I'm probably going to end up in liquidation. So the issue of timing is really about preventing directors from trading in insolvent circumstances where they know incurring credit is going to translate into personal liability. Because if you tell your supplier, yes, I'll pay you in 30 days, but in fact, I know that in 30 days I won't have the cash, that's dangerous. Section 22 of the Act, it specifically says you're not allowed to trade, or the company mustn't trade recklessly, negligently, or worse, with an intent to defraud your creditors. So it's that twilight zone, we call it. Maybe you can hear the music in the background, but it's the twilight zone when you are reaching a point that if you don't file now, and you've got to make the unemotional decision, which is sometimes very difficult, particularly in small family-held companies where the grandfather started the business, and now we've reached difficult times. Why am I, the grandson, going to actually file for business rescue? Why should it be on my plate? But sometimes, as I said, the hard and tough decisions need to be made.
It's about doing the right thing, and I think that's the point of being in charge. It's about having to look at what the options are and do what's right for the company, and make sure that, like you say, we're doing this before there is no value left in the company. So let's go to some of the questions that are live. We've got a question in relation to financially distressed companies. You spoke a bit about SAA and what's gone on there, but has the SAA Labour Court appeal judgment infringed or interfered with the director's fiduciary duties to change the business and retrench employees in the ordinary course prior to the publication of a business rescue plan? So this speaks a little bit to what we've been talking about, but has that judgment infringed on the director's duties, the fiduciary duties?
So the Labour Court decision, which actually has been confirmed on appeal, so it went on appeal, and the position is simply this, that the Court of Appeal has said, once you are in a business rescue, the 189 process shouldn't be continued with, or commenced rather, until there's a business rescue plan published where the employees and trade unions can actually see what the prospect looks like in respect of retrenchments, where do employees stand, etc. Now, it's a very difficult one because many business rescue practitioners don't get to publish their plan until months into the process, even though there are short time frames within the legislation to do it quite early. But in practice, particularly in the bigger ones, excuse me, you find that business rescue practitioners just are not able in the short term to file their plans. So how does the company continue to trade when they've got a massive bill to pay employees? For example, in SAA, you can understand, I think there were almost 10,000 employees, and the company was running out of cash. So the practitioners wanted to run a 189 process, a retrenchment process, in terms of the Labour Relations Act before publishing their plan. And they couldn't do that because the labour unions took them to court. Now, it makes practitioners their task extremely difficult, because now they have to wait for the business rescue plan before they can in fact start a retrenchment process. Time will tell how that plays out in practice, but it's not going to be easy for practitioners going forward.
And I think in line with that, Eric, I mean, I was looking at some of the stats around actual business rescue practitioners in South Africa. I think the demand is going to increase phenomenally in the next, in the coming months. Do you think that we actually have enough of these skilled restructuring experts to deal with the amount of demand? I mean, I think at the last count, you said we had about 460 licensed practitioners, and only about 97 of those were senior. So do you think there's enough to deal with what's going to happen in the coming months in South Africa? And if not, what are the other options for us?
So as you said earlier in the introduction, which I must thank you for, I am the chairperson of SARIPA, the South African Restructuring Insolvency Practitioners Association, a very long name, but we call it SARIPA. And what we try to do is, obviously we deal with liquidation issues, we deal with business rescue issues, and what we're trying to do is to uplift the number of business rescue practitioners involved in this profession, because we do need an increase in senior practitioners. As you said, we've got about 95 experienced practitioners and about 97 odd registered senior practitioners, and we don't believe that's enough, particularly in the bigger filings that we're starting to see. Now, as I said, it's all about training. It's about doing courses on business rescue. It's about belonging to organizations like SARIPA, to be able to become upskilled in understanding what this is all about. And I can tell you that the more people that get involved, the better for South Africa and the better for the profession, because it is not something that's going to decline. In fact, we are expecting between now and the end of the year an increase in the number of business rescue filings. And I'm not just talking about business rescue practitioners, I'm also talking about restructuring experts, turnaround experts, people that play in the distressed environment. And the more people that we can get on board, the better. And it does need people to come on board and to contribute to what at the end of the day is about job preservation and rescuing companies, putting them back into the economy on a solvent basis rather than allowing them to end up on the liquidation scrap heap. So it's I'm not going to say it's a rewarding profession, but for me it is. But it's certainly something that contributes to something that's positive. Liquidation is something that has to happen often, but the business rescue process, the restructuring process, the ability to give a company a fresh start is something I would encourage people to take on board and become interested in this area of law and of practice. Yeah,
I would agree. I think there'll be much more demand, and it's like you say, I think it's work that is purposeful, because you can see an outcome. It must be very fulfilling to work in an environment where you help a company, go into business rescue, and many lives, that go through that process are saved in terms of making sure that people have an income they can take home. So definitely something that people should get involved in, I think.
Just on that, Vidisha, directors come to us and they're like rabbit in the headlights, or someone told me it's not rabbit in the headlights, it's deer in the headlights. Yeah. I think it was an American who said that to me. But, directors don't understand what they are letting themselves in for if they don't embark on the process. And it's about panic and, a situation where they do not know where to turn. So when you talk about the rewarding aspect, you calm directors down, you calm management down, you tell them about what rescue can offer and what the objectives are. So there is some, upside to being involved in this process.
So we've got a question from Albie. I think sometimes, you could have a proposal that says, I think we need to get a business rescue practitioner involved, but there are objections from the business. It's generally seen as an expensive process. Is this a valid perception? Or how would you handle that sort of objection from a business?
Vidisha, that is an interesting question, because people don't really understand that when a company goes into rescue, the funding of the practitioner and the expense that goes with the process is paid for by the company. So if the company doesn't have that ability to, in fact, at the very least, pay its restructuring experts or its business rescue practitioner, again, we're talking about liquidation, because they've basically run out of cash, so far gone that business rescue is not even an option. So I must be frank about it. I don't believe that business rescue is for the small companies, let's assume the small SMEs necessarily. I have seen it work in smaller companies, privately owned companies, quite successfully. But, you can't be very generalized about it. It really depends on the company, on the willingness of management and directors, and of course the buy-in of stakeholders, the creditors, the trade unions, the employees, suppliers, to come along on this journey, which really is all working together. Because if people go, as we say, off piste, it's going to end up very badly, and you're going to have a situation where it's probably going to end up where a plan cannot be put together, and really the plan does not get approved, and we end up, unfortunately, in liquidation. So it's not for everybody. I think it comes down to taking proper advice from professionals as to whether or not this particular company is indeed a candidate for a process like business rescue.
All right, so we have lots of questions. Should we go through a quick tirade? Maybe just try to help us get through. We've got 17 plus another 17 on chat. So I'm just going to read them out. What happens with pension fund contributions that the employer is legally obliged to pay in terms of Section 13A of the Pension Funds Act?
Okay, so the pension fund obligations remain intact. In fact, the Act specifically says that all labor relation issues or employee related issues must remain in place in terms of the Labor Relations Act. There's a special carve out there for employees. There's two aspects I'd like to raise here. One is that any employee that has a claim for unpaid salaries, for example, would be a creditor in the process. Unfortunately, their claim pre-commencement might be compromised. And if that employee continues to work within the company once it's gone into rescue, they in fact are preferent. They are in fact categorized as post-commencement funders in a very strange way. They're elevated because of the fact that they are working for a company now in rescue, and they would be paid before anyone else. But pension fund claims, employee-related claims remain intact. People often, Videsha, make the mistake of thinking that business rescue equates to liquidation. It's not. Liquidation, employee contracts come to an end, and there are statutory claims that have to be filed in terms of the Insolvency Act with a liquidator. Business rescue is a different animal completely.
Yep. And it's why it's the preferred first step, because it does give you more to work with. So, question from Jane. When one has a personal suretyship, are you able to sue for funds from the suretyship while the death rescue process is still ongoing, or is that suretyship then frozen?
Very good question. I think Jane probably is a lawyer, but I might be wrong. So we've looked at this in great detail over the years. Generally, what we tell people to do is to look at the suretyship very, very carefully, because the suretyship relies on a principal obligation. So let's say a director signed a surety in favor of a supplier for the debts of the company, and the company goes into business rescue. The question is, can you go after the director on the suretyship document? And provided there is a clause in the suretyship itself which preserves the right to still go after the director, notwithstanding the principal obligation might have been compromised in the business rescue plan, those rights remain intact. And sometimes we even see business rescue plans in the provisions in the plan itself making provision to allow creditors to still go after directors on suretyships, notwithstanding the fact that the principal obligation has been compromised. We, in fact, have advised clients to rather get guarantees signed and not suretyships from directors or other guarantors, because a guarantee in law is an independent obligation. It's not reliant on an accessory obligation like we see in the suretyship. But a very important concept. There's been some cases. I've dealt with a lot of those in my book. But interesting cases on suretyships and where they land in the business rescue.
Cool. I've had a few of these now. Can you please elaborate on what constitutes a successful business rescue? So what would you think are the metrics or the elements or the, in terms of execution and what happens thereafter? What is a successful business rescue intervention?
Again, one that's been debated in the courts. The famous case of Oak Dean started that debate some years ago. As I said earlier, there are two objectives in a business rescue. The one is, and for me, obviously, I think for everyone listening in, must be the ultimate objective, and that's to rescue the company. Keep the company intact, try and keep management intact. Look at the historical debt, make sure it's compromised down. Creditors say, okay, I'll take 20 cents in the rand, it's a lot better than nothing, and approve the plan. And then get the plan implemented by management, the board, and the business rescue practitioner. And then what happens is the company exits from the business rescue process, hopefully solvent, and can continue to contribute to the South African economy going forward, with jobs preserved, and there's not this massive fallout like we see in liquidation of job losses. That, for me, is the pinnacle of a successful business rescue. Now, sometimes it doesn't work out that way. And once a practitioner looks at the nuances in the particular mandate, he or she might say, you know what, we can't rescue the company in its current frame. Let's sell the assets, let's sell the business, or perhaps let's in fact sell the shares to a third party. And let's get a better dividend for creditors than they would get in a liquidation. Now, as I said, liquidation dividends, the starting point is generally zero. So you're always looking at a position where creditors will feel, as I always say, unhappily happy to take something better than zero. It's all about compromise. And that's the international framework of rescue. We never had it pre-2011, now we've got it. And that's something which I said earlier, it's all about education, to understand what is the upside of a business rescue and a successful business rescue. And I want to give you an example, Videsha. If everyone recalls Stutterford's went into business rescue, and the practitioner there took a view on the second leg of the outcome, the second objective. And he decided to rather provide creditors with a better deal than they'd get in liquidation. He sold off the clothing stock in a very controlled fashion. He believed in a much better way than would have happened in a liquidation. And the outcome was obviously a better deal for creditors than they would have got had the company gone into liquidation. So it's almost like a wind down, the second part, which delivers a better outcome. So those are the two objectives. Of course, the first one is always the better one. The second one, depending, you might have a third party buying the business or buying the company, and the company continues to trade, but in a different format.
Another question from Anonymous. Eric, do you consider that creditors whose lending is secured in one form or another should be allowed to vote on a business rescue plan? What is your thinking?
I know where that comes from. So I may be anticipating the question, but one of the issues in South African Airways was a lot of the banks have guarantees from government, okay? And the question is, do they get to vote on an independent basis because they, in fact, are guaranteed their outcome? And there was a whole debate, and I think at the end of the day, the banks got a vote, and they were deemed to be independent. So the fact of the matter is that even though you might be secured, so let's assume a bank has got a mortgage bond over property or has a general notarial bond over the assets of the company, it doesn't matter. They still get to vote on the plan at the same level as any other creditor. The fact that you hold security doesn't give you a more enhanced vote or a decreased vote. Now, when I discussed that aspect with some of my colleagues in the UK and in the United States, it's a very interesting concept to them, because in those jurisdictions, secured creditors have a much bigger say in the restructuring outcome in Chapter 11 or in the UK administration process. So to answer the question, it really comes down to everyone votes in one pool. Concurrent creditors vote with secured creditors, and that is the South African legislation. Everyone votes in one pool. You've got to get the plan through at 75% of all creditors voting in value, with 50% being independent, and then the plan would be approved.
Okay, Makes sense. Just a note, Jane wanted to let you know she's not a lawyer, but she was well trained many years ago as a credit manager by Dove Judah
Ah,
Farmworks.
he was a partner at my firm, yes, a doyen in insolvency, actually.
Okay, so some other questions that we have. I'm looking for themes so that we can get to more of them. To what extent does SIPC's moratorium on enforcing its rights under Section 22 of the Companies Act protect directors from charges of reckless trading? And maybe you want to give us a little bit of an overview on the director's liability under this as well.
Sure, a very interesting question. Just to start off, we've seen overseas in other jurisdictions that directors have been given a moratorium on trading recklessly, just because of what's gone on with COVID and the fallout for companies and the economy, etc. Now, firstly, let's just start with the Section 22 position, and I'm not going to get into the details. Section 76 talks about directors that acquiesce in reckless trading could be held liable. Section 218 of the Companies Act also makes persons who don't comply with provisions of the Companies Act also liable to other parties. But fundamentally, 22 says if you trade a company recklessly, negligently, with an intent to defraud creditors, you will be held personally liable. Now, what happened in the early days of the lockdown is SIPC put out a notice to say SIPC as a commission, will not prosecute any directors or individuals for trading in contravention of Section 22. Now, that was a very noble and good outcome for directors, because obviously a lot of them had to close down. There was no revenue generation in COVID, in the lockdown, and that made sense. But unfortunately, the interpretation from a legal perspective, it doesn't stop third-party creditors who are being prejudiced by reckless trading from suing directors personally for reckless trading. So even though SIPC gave a moratorium, in our view, and I think that's the current view, and certainly Saripa's view, it doesn't stop creditors who, for example, are trading with a company and that company cannot pay them, and there is reckless trading for not going after or preventing them from going after directors for reckless trading. So directors need to be very careful in relying on the SIPC moratorium, because even though SIPC might not go after you, a third-party creditor might.
Makes sense. I see we've had quite a few comments and questions around Saripa membership, and as well as what are some of the skill sets that you need to have to become a business rescue practitioner. I'm not sure, Eric, but how would you like people to contact you directly?
No, I wouldn't want them to contact me directly. I prefer them to go to the Saripa website. It's www.saripa.coza. All the information is available there, and our people will obviously take on board applications and explain how you become either a registered insolvency practitioner or a registered business rescue practitioner. What is important, and people might not realize, is that SIPC provides licenses to both insolvency practitioners as well as business rescue practitioners. But you also need to belong to what we call an accredited association, like Saripa, like the TMA, like the Law Society, and others. SICA is another one, and Cyber is another one. So it's quite well regulated in the sense that we try and ensure that when people do get licenses, they practice, at the right level. Proper due diligence is looked at when they take on mandates, and that those licenses remain intact. So that's how you go about getting licensed and to become part or a member of something like Saripa. All the detail is on the website.
Okay, we've unfortunately run out of time. Still a lot of questions. In conclusion, I'd like to thank all of the participants, but most importantly, thank you, Eric. I think today has been very informative on many levels, and you've given us many things to go think about. And thank you for also allowing us to understand more about business rescue and how it is an alternative to some of the other avenues. As we said, we have partnered with Eric again, and he has authored the South African Business Rescue Procedure, which is one of the books. And on screen, you will see the discounts that Eric is affording to only the participants that were online today. You will be given a voucher code from webinars at LexisNexis.co.za, and please use that to entitle yourself to some of these amazing offers. So 10% store-wide discount on the LexisNexis e-store on selected titles, which obviously includes Dr. Levenstein's book as well. And then 20% off our corporate governance and business procedure bundle as well. So as I can see, there's so much going on and many questions that are, still to be asked. So a lot of interest in this field, and Dr. Levenstein's book will probably be the best place for you to get the answers to a lot of those questions. So please take advantage of the offers. And once again, thank you, Eric. We are very honored to have
I appreciate it, and I certainly have enjoyed the afternoon's discussion. Thank you.
Thank you. And with that, we will close. Thank you, everybody.